Good morning, everyone, and welcome to today's hearing. Before we hear any more evidence, we're going to deal with the various procedural matters which I referred to at the hearing when we finished in August. So I'm going to begin by inviting Mr. Millett to say a few words.
Mr. Chairman, thank you. Given the need to keep this procedural hearing to the 90 minutes you have allocated, I propose to say very little. We have had a large quantity of helpful written submissions from core participants, from whom you will hear further this morning in accordance with the timetable that the inquiry circulated on Friday. I'm not proposing to set out the inquiry team's position at this stage because you, Mr. Chairman, will need to consider all the submissions in the round and decide what to do. I will confine myself to three topics. First, the boundary of issues between Phase 1 and Phase 2, so far as concerns the evidence of senior LFB officers. Second, urgent interim recommendations. And third, what we have called the Article 2 process. Turning to the first of those, the boundary between Phase 1 and Phase 2, many CPs want us to expand the scope of the evidence to be asked of senior firefighters to extend to matters that are not about what happened on the night of the fire, but much wider background questions, such as questions about training structures, delivery, their adequacy, outsourcing, equipment, funding, and the particular personal opinions of those senior officers about fire safety, stay put, evacuation strategies, etc. One group has even suggested that the senior officers should be questions about interim recommendations themselves. Mr. Chairman, the inquiry team's position is that these are issues manifestly for Phase 2. Although the boundary between Phase 1 and Phase 2 is sometimes elusive and flexibility has been needed and will be needed at all times, the basic line is, I hope, clear. Phase 1 is concerned with the primary facts as to what happened on the night of the fire. As part of that, it has been and will remain necessary to explore what decisions were made or were not made by decision makers and on what material basis they were made or not made. This approach may well, to date, have started to reveal gaps in policy, inadequacies in training structures and delivery, misunderstandings of obligations or policy, and a lack of consistency. But it would be wrong for any of us to comment on the evidence so far. To the extent that failings have been revealed, Mr. Chairman, you must keep very firmly in mind two things. First, that the evidence on Phase 1 is very far from complete. And second, it is vital to take these questions in stages. There is a temptation, of course, to get into these issues with senior officers while they're here at Phase 1. Tempting, but wrong. It would also be wrong, we say, to say that just because we are looking at the question of urgent interim recommendations, therefore now is the time to expand Phase 1 and start asking senior LFB officers about them. Getting into issues of who designed and updated training programs and policies, or whether the LFB was properly funded, are incapable of being broached without a mass of further disclosure and some focused witness evidence. We must remember that the police, and not the inquiry, have taken the firefighters' statements, and they have not focused specifically on these issues. To the extent that firefighters do sometimes cover these issues in their statements, it is, perhaps unsurprisingly, piecemeal, unevenly distributed, and incomplete. A full and focused and unrushed evidential exercise with the benefit of full disclosure and the right witnesses will, we think, produce far better and more reliable evidence than simply throwing questions at senior officers just because they're here. If any senior officer needs to be recalled, and we anticipate some will have to be at Phase 2, then we will recall them. At the moment, our proposed approach is to treat all London Fire Brigade witnesses in the same way, and to ask them detailed questions about their experience of what happened on the night of the fire and what was the basis of the decisions that they made or did not make to the extent that they did so. It would be wrong, and we say unfair, to ask even the Commissioner detailed questions on, for example, the tendering process and pricing process by which Babcock were retained to deliver training to the brigade, without at least her having the benefit of some documents and a chance to think about it. It may well be vital stuff, we can see that, but not for Phase 1. Turning to Phase 2, interim urgent recommendations, the process of core participants thinking about all of this over August has, we think, proved useful. What has emerged is a wide disparity of approaches as to what can and should be done and when. No clear consensus has emerged from core participants who have addressed the inquiry so far in writing about what is so obvious and dangerous that you need to and can make recommendations now without hearing any further evidence or any further views from anybody. What is clear is that a considered, even-handed and evidence-based approach is needed. Some BSRs have suggested that as part of Phase 1 we should have some evidence from the LFB as to what they have done post-fire to address the issues that the fire has thrown up. We do see the force of that suggestion, and it might be helpful as a first step for the LFB and indeed the MHCLG, the Home Department and the Mayor's Office to explain in writing what they have done and what they are planning to do to respond to the fire and to the lessons learned so far. In the light of that information, you then, Mr. Chairman, can then proceed to consider what, if any, urgent interim recommendations ahead of a Phase 1 report you might wish to make. I would suggest that once we know what the LFB, the MHCLG, the Home Department and the Mayor's Office have done by way of position statements to be served in accordance with a sensible timetable, then you can consider a structured programme for further consideration of interim recommendations. This programme would, we would think, say, likely include input from inquiry's experts and core participants and some further days of hearing at a convenient point. I would suggest that this process and any further hearing takes place once the expert evidence is concluded at Phase 1, but before the Phase 1 report is produced. As LFB have pointed out in their written submissions to you, there is a range of consultees who would need to be consulted about urgent interim recommendations, and you would need to consider carefully the nature and the extent of any wider consultation once the range of possible recommendations has been identified. Finally, Mr. Chairman, can I turn then to the question of Article 2? As the evidence, particularly about fire survival guidance and communications, has started to emerge, there is a growing case for a piece of work which ties all of this together, deceased by deceased, in order to satisfy as much of the Article 2 requirements as can be achieved at Phase 1. The RLRs for the BSRs have volunteered to undertake it, and I, for one, would support that. I would also strongly support the idea of having a set-piece hearing at which the advocates for the families present the evidence relating to their lost loved ones. I would suggest, first, that there would be an agreed set of written summaries of the relevant evidence in a format to be agreed with the inquiry team. Second, it would be provided after the end of the expert evidence. Third, there would then be an oral hearing during the Phase 1 report writing period of a number of days to be agreed, at which the advocates for the families presented the material to you. Fourthly, each advocate would work to a strict time budget and in an order to be agreed between themselves and with the inquiry. And then finally, the results and your findings would be reported on in the Phase 1 report, necessarily as interim and incomplete conclusions, not least since the toxicology evidence will not necessarily be complete by then. And there may well be other matters in phase 2 that go to the question of how the deceased's came by their deaths. In this way, the BSRs, and particularly the families of the BSRs, of the deceased's, will have been heard both at the start and at the end of phase 1, and they would have full participation in the detailed evidential work about their loved ones. We would hope, Mr. Chairman, that this arrangement would offer at least the start of some kind of closure for those individuals who, we must remember, always were dreadfully affected by the terrible events of that night in June last year. Mr. Chairman, thank you.
Good. Thank you very much, Mr. Millett. Now, the timetable that I've been provided with suggests that the next 30 minutes are going to be shared between what we now call the G4 group, the G11 group, and the G3 group. So I hope you've talked to each other about how you're going to share the time, and you can tell me now who's going first.
I think I'm going to go first.
Right, Mr. Friedman. I suggest you come up and use this spot. Thank you. Can I suggest, bear in mind that you've helpfully provided me with some submissions, which I've read, of course, and shall read again. So probably the best thing is to focus on the points that you think are most important.
Yes, I'm grateful, and I believe we all will do that. Thank you, Mr. Chairman, and thank you, Council, for the inquiry. Every public inquiry of this nature and magnitude has to start its train running and lay its tracks as it goes along. For some, the train is running too quickly. For others, the train is not fast enough. People can properly disagree about that. But having constructed a phase 1 to establish the facts of the cause and spread of the fire and how it was responded to, this first journey must be brought to its proper end, and the 4 items on your list for today ask us to reflect on the next parts of the track. Item 1, and the scope of the senior officer's phase 1 evidence. Based on your council's questioning to date, the main frontier between the 2 phases relates to policy, training and equipment. Most witnesses have been asked about how their understanding of those 3 things affected their response to the fire, and it must follow that the senior officers should be asked the same. For our part, phase 2 can then consider deeper background and responsibility for guidance, curriculum and procurement, and indeed recommendations for long-lasting national change. However, for the senior officers, and this must at least extend to Commissioner Cotton and the Assistant Commissioner Rowe, we submit that the inquiry's questioning in this phase should go just 2 steps further. First, we would want the witnesses to be asked about their knowledge of any deficiencies in policy, training and equipment before the fire, so as of 13th of June. So to take now obvious examples that have arisen with scores of witnesses that you have already heard, what was their awareness of station level understanding of cladding fires, and when and how to revise stay put when those watches were called out the following night? Equally, just as others have been asked to comment on the lack of contingency planning for Grenfell, so should the senior witnesses, particularly with regard to why policy 633 on high-rise buildings and policy 800 on risk management did not trigger better planning and more rigorous familiarisation. All the more so now, given that the standing action plan in response to the Lacknell House inquest intended that they should. The witnesses should therefore be shown the content of the premises risk assessment, the Section 72D visits, and the operational risk database as they related to North Kensington's work, and should be required to confirm whether or not the content was fit for purpose. Paragraphs 7 and 8 of the written submissions provides our fuller lists of what matters would fall into this category of questions. Our second step further is essentially a matter that has been recommended by counsel to the inquiry, and I know Mr. Steen has written about this to the inquiry and will develop it. But we agree that either through the commissioner herself when she gives evidence, or at some other appropriate point, the London Fire Brigade should be in a position to give its interim response or position statement about the facts as they understand them to be, indicating what changes have already been put in place with regard to policy, training and equipment as a result of the Brigade's own review. This does not have to be a finalised position, and indeed there is great merit in sharing a provisional analysis and allowing this inquiry to assist in its evolution. But what cannot be right is to wait until phase 2 to begin that public dialogue. Your second item, sir, on the list concerns arrangements for the bereaved and surviving witnesses to give evidence about the night fire. Can I limit my oral comments to the issue of venue? And can I say that we praise the work that's been done on this building to make it better throughout the hearings that have gone on? But we do want to return to the Millennium Gloucester Hotel or a similar venue for the short period of time when the survivors and other family witnesses give their evidence. The arrangements for taking evidence during the commemoration hearings worked exceptionally well. Those hearings gave this country a gold standard for the future in how to approach the giving of evidence by victims in disaster inquiries, and one of the main reasons for the quality of that process was the venue itself. There was a great deal to value in being in a space that was formal and focused and yet not confined, and that will be the problem here. The numbers of bereaved and survivors who will want to come to the venue when we start this part of the evidence will be the same as those who came to the commemoration hearings. It is therefore important for the inquiry to search one more time, we say, and that the hugely positive potential of alternative hearing space should not go unexplored. Your item 3 is the Article 2 inquest function, and we welcome the indications of Mr. Millett, and I think you know that we and others are ready and willing to work on that piece of work. You would have seen that our team and Mr. Weatherby and Miss Murphy have suggested a broadly similar approach whereby you would dedicate a period of hearing time where the evidence in relation to each of the bereaved households can be appropriately presented to you. Together with our clients, we would prepare presentations. The content would include the recalling the background and relevant personal characteristics of each bereaved, for instance, their age, disability, or if foreign language was their first language, the 999 calls and the FSG handling, the known migration between flats during the fire, firefighter deployments into the tower, the last known contact with either survivor, firefighter, or control room officer, the CCTV evidence, the location of body and remains, and post-mortem and toxicology evidence where available, and we hear what has been said, that that may be a subject that will be continued into the second phase. The value of the approach is that it would draw all of the strands of the evidence into one dedicated process, which the bereaved could attend and the public could access. And hitherto, the evidence has come out in an important way, but it has come out in fragments. And this is the opportunity to take it into the next stage. The part of the process that we would want added into what has been explained is an opportunity to summarise the most relevant aspects of the 999 calls in a public document. It would demonstrate how and from whom the calls evolved over the night. What the evidence heard by the inquiry does not do at present is show in one place the core matters of what the occupants were saying and what was being said to them. That schedule would be an invaluable testament to the essential words of the callers, but also a crucial training document for control room and operational officers for years to come. In addition, when the fate of each household is focused upon, we do wish to apply for parts of the calls to be played. Some families will not want this, and that must be respected, others will. How certain things are said by callers or operators will be of forensic value. But we know that there is a strong feeling from some bereaved that the words of those who die should not be diluted through summary and transcription, but that some of what they said should be heard as a remark of respect to them, but also with respect to a grown-up public that needs to learn what it is like to live and die in tragedies of this nature. And it goes without saying, in any ordinary inquest or piece of civil litigation, if there were core last calls in relation to a deceased, they would be played, and that should be done proportionately here. Final item, number 4 on your list, is the approach to interim recommendations. You will have seen that in process terms, we've suggested 3 categories. Broadly, category 1, the manifestly obvious. Category 2, that which requires more evidence to be served as soon as possible in order for you to make meaningful phase 1 interim recommendations. And category 3, that which requires a declared intention on your part to investigate during phase 2 and for you to require interim reports in the manner described by Mr. Millett in order to enable you to do that effectively. Whatever you choose to recommend on an interim basis or defer to later inquiry, we would first of all value a timetable from you to lodge proposals, indicate the evidence we rely upon, and respond to other proposals just as others should respond to ours. Taking steps to obviate future risk could not be more important. That said, one of the lessons of the Lacknell House inquest is that well-structured recommendations can get lost in their implementation unless they bear the authority of an in-depth public inquiry that has comprehensively investigated the issue, including consulting widely and transparently in a way that neither Parliament nor government could ordinarily do. The would-be implementers of change have to appear before the inquiry to communicate their stance on reform, rather than be left to do so after the inquiry has closed its books. Experience from other inquiries shows that seeking their interim thoughts is the best way to correct continuing denial of the problem or encourage organisations to be more creative and accountable. That is why we categorise the threefold approach to recommendations as we do, why we are interested to learn the plans of government, the local authorities and the fire brigades sooner than later, as should you, sir, and why we would like a timetable for informed and considered submissions to be made. Thank you, those are our submissions.
Thank you very much. No, Mr. Steen, are you going next? Yes.
Sir, thank you. May I first of all deal with the hearing itself that we are embarking upon this morning? May I gently, if I may, submit that these hearings, procedural hearings of this type, should be left for Fridays. There is a real danger that by having such a limitation of time and on, as an example, the number of pages for written submission, that the voices of our clients, the bereaved survivors and family members, will not be fully heard. May I, after that point, move on to our substantial submissions? You know from our written submissions the points that we take generally. I therefore target 2 particular matters. Mr. Millett has started this morning by outlining incredibly helpfully that he agrees that a first step for the London Fire Brigade, MHCLG, the Home Office and the Mayor's Department should be to explain what they have done since the fire. We have called for this. I know that having spoken to my learned friend, Mr. Walsh, Queen's Counsel, that he agrees on behalf of the LFB with this principle. That assists and in fact shortens my submissions.
Good.
We do need to get started on the process of change within the LFB, and we need a pathway so that we can find out through working through the material what has been done since the fire to see what should be done in the future. May I cite some examples? If radio communications within the tower for firefighters were better, then the fact of the speed of the smoke and fire going up the building and being discovered by firefighters may have been better understood by senior command firefighters. If training was better, W.M. Dowden may not have been so overwhelmed by the decisions he had to make. If the systems of command had greater flexibility, then decisions may have been made faster, and if the LFB had had a plan B for coping with a complete failure of stay put within a high-rise block, the death count may well have been lower. We submit that the LFB should have carried out training exercises in the past, dealing with a full block, high-rise block disaster. If so, then the problems and issues that we have discovered through evidence from the astonishingly brave firefighters who entered the building may have been revealed through training and not through a fire. This is the capital city. We have tower blocks everywhere. Roughly 8% of the population lives in residential tower blocks. There is no evidence at the moment that there had been any training or contemplation of mass evacuations. The radios couldn't communicate beyond the first few floors. There are real questions about whether FSG calls could be handled in this numbers. We stated in our letter of the 13th of August, and it is our submission, agreed it seems, and we are grateful again to counsel to the inquiry, that these sorts of issues lie in both halves of this inquiry. Changes in these areas need to be made. We know that. But first of all, we need to see what has happened. If you come to the view, sir, assisted by submissions, that current plans and current changes that are being considered by the London Fire Brigade are insufficient, then you can urge, recommend, make comments as to where plans and policies should be considered for change. The alternative, issues such as training and policy regarding firefighting in high-rise or indeed complex fire scenes, will be left until your final report. There are a number of documents that we know are available on open source material. These are such documents from the LFB dealing with the replacement of incident ground communications, the setting out of £1.6 million to pay for new radio sets. That, as far as we are aware, is not available on the inquiry material. Other documents issued by the National Fire Chiefs Council, which has looked at the question of research being taken place to establish technical options relating to a change from analogue to digital radios, is not available on our system at present. Other cities around the world have looked at these issues for obvious and good reasons. As an example, in New York City, they use an ARC system, an auxiliary radio communication system. And that provides more effective communication for firefighters, even when separated by thick floors or concrete walls in a tall building. These are the types of points that we suggest should be looked at by the London Fire Brigade and considered and answered in detail so that we can see what has happened within the Fire Brigade, I agree with Ms Millett, within the Home Office, so that these matters have been considered. Let me be true to my promise and cut down the nature of my submissions and move on, therefore, 2 pages. Right. I move on to the imposition of a moratorium on A2 specification and below cladding materials being used on blocks. The Royal Institute of British Architects Executive Director of Professional Services, Adrian Dobson, recently said, continuing to allow materials of limited combustibility, A2 classification, is unacceptable in the wake of the tragedy at Grenfell Tower. And the evidence from the UK and around the world that these materials do not provide adequate protection for the public, and he went on, banning these materials is the first step towards restoring the trust in our regulatory system and the building industry. Any of the responsible commentators that have looked at this area say that there needs to be direct, real, immediate change to the building industry, to the construction industry, and to the regulatory system that chooses these materials. Now, we cannot necessarily take all cladding off all buildings, but we can stop it by having a moratorium on the use of such materials on buildings. That is the position that we set out in opening. We maintain that submission, and we urge this inquiry, after the due process of submissions, perhaps on a Friday, and in writing, to consider the ban by way of a moratorium, so that we do not put such dangerous materials on buildings at this stage until we know that the type of cladding that can be used is safe for the people that live within these buildings. The last point we make on that is this. Currently, the system of regulation, such as it is, does not include people that live in tower blocks, or indeed work in them, such as an office block. That means that the very people that take the risk of living in such buildings have not had part of the decision-making process leading to the question of how should risk being assessed. Till that is done, the very people that might suffer in the future will not have considered what risk they are prepared to make, rather than the people that are producing these materials. That is an added reason why, for the moment, there should be an immediate ban and a moratorium on the use of such materials. I hope I've not strayed over my 5 minutes.
Well, you have, but I don't think anyone's going to criticise you too heavily for it.
Thanks, sir.
Thank you very much. Yes, Mr. Weatherby.
Good morning, sir. The first issue, the nature and limitation of the Phase 1 evidence. I'm grateful to Mr. Millett for his comments this morning. We raised 4 points in our written submissions, and I'll very briefly go through a couple of those points. In our paragraph 1, we sought clarity over the extent to which the inquiry is going to deal with the issues such as the apparent failure to establish command and control, to understand that statehood had become untenable at a very early stage, formulate an alternative plan, and when such procedures were to some extent put in play, for example, by Group Manager Goulbourne, who we'll hear from next week, whether it was too late by then. As I understand Mr. Millett's submissions this morning, we're on the same page, and those will be fully dealt with in Phase 1. If that is not right, then we would seek some clarity about that in terms of what will be left over till Phase 2. We would add that although we understand that all witnesses must be treated with similarity, we are now moving on to deal with managers and commanders, and we would therefore invite the inquiry to take a robust line in terms of looking at this evidence and drilling down into this evidence in a way that perhaps hasn't been appropriate with those more at the front line. So what we mean by that is the putting of alternative hypotheses and, where appropriate, the challenging of this evidence. We've made submissions about who should be asking questions of these witnesses, and I'll say no more than that than's in our written submissions. Finally, on this point, we have raised the issue of the process on lines of questioning, and we would invite the council team, where an issue is raised by us or others, and it isn't deemed to be appropriate for Phase 1 or at all, that we should be given some greater advance notice of that in order that we can take it up with them.
Speaking for myself, I don't have any difficulty with submission, but I think everyone needs to bear in mind that it's a process which requires questions to be put forward well ahead of time.
Yes.
And I think sometimes questions are coming through very late in the day, which doesn't allow for that sort of
we've all heard that, and indeed we've tried to address that, and no doubt it won't be perfect, but we will certainly endeavour to do that to the greatest extent possible. The second point about the evidence from our own clients. Two small points about this. First of all, after the rise of the hearings on the 2nd of August, we were sent letters. They were sent to each of these solicitors about their own clients and not more generally. We were surprised by the small number of our clients who have been minded to be called to give evidence. And we've sought, as a matter of transparency, the full list of minded to bereaved and survivor evidence in order that we can make further proper submissions. We've submitted submissions in writing, but we seek, as a matter of transparency, and so we can make those proper submissions, the full Minded To list. At the moment, your team have declined to provide that to us, and we can't see any basis for that. And in order to take this process forward, we seek some assistance with that. So 2 points. We would like the list, and then we would like to progress our submissions with counsel to the inquiry. In terms of the Article 2 process, we presented in mid-August the inquiry with a written document which has been referred to by Mr. Freedman. It appears that we're all on the same page here. There are minor differences over timing, which I won't speak to this morning. Only this to say is that this is something which is absolutely vital to the bereaved in terms of putting this evidence into a coherent form. But it's also vital to you and to the inquiry generally in allowing for the full Article 2 requirements to be done. So we commend that, and I won't repeat what's been said at all. Mr. Steen has spoken about interim recommendations. We're here talking about process. Our submission is quite simple, that generally, as a default part of the process, recommendations follow the evidence and the fact-finding of the inquiry. But you have the power in law to make recommendations as and when necessary. And we do say, for the reasons we've set out in writing, that consideration of the moratorium is necessary. There are 2 points I would add to those that have been said. The first is that on the 20th of August, the Equalities and Human Rights Commission, the independent state human rights watchdog, has made quite clear that their view is that there is a continuing breach of Article 2 in respect of the insufficiency of the system of regulation that's been pointed out by others, including Dame Hackett. And that will not wait in our submission. And secondly, we pointed out in our written submissions that Kingspan, amongst others, are still marketing the very combustible materials for use on high-rise blocks. And we say that those factors are key in saying that it's necessary now and urgent now to consider a moratorium. A moratorium is proportionate because it deals with the immediate issue in the context that there are remedial works going on around the country or planned to go on around the country. A moratorium does not prejudge the final outcome of this inquiry or other processes, but it is proportionate in dealing with the immediate issue that Mr. Steen's already spoken to. There was one other issue that we added in our written submissions to your agenda, and I hope in the remaining minute or so that I can just speak to that, and that is the issue of disclosure. And I make no apology for returning to this issue once again. We've had repeated assurances from the inquiry team that it's disclosing all relevant material. We currently have received less than 5% of the documents that the inquiry team has had. We have attempted repeatedly to work collaboratively and cooperatively with the team, and no doubt your council team will confirm that to you. But nevertheless, in a number of areas, disclosure remains a serious concern to us. We have taken many months to persuade the team to disclose basic materials such as the CCTV footage. And we thought before the break we'd reached a position where we'd resolved the issue of what the inquiry has in terms of the firefighting evidence, and that boils down to the lists of documents that the LFB had provided to the inquiry, and we thought we'd resolved that issue. In fact, in neither of those issues have we yet received the material. I'm told that the CCTV footage, or some of it, is imminent. And we would urge the inquiry team, and I would urge with respect you to nudge the inquiry team to deal with both of those issues urgently. Right. Yeah. There are a number of other issues about disclosure, but there are more issues of detail, but they reinforce this position. They go to issues such as EDBA firefighters, whose evidence is becoming critical in the next week or two, and some of those statements remain outstanding. and indeed communications logs from the police and the ambulance service, which the inquiry team indicated were on their way at the end of July, and they're still awaited. So we say that effectively, although there has been progress in terms of disclosure, there needs to be something of a culture change within the inquiry team to actually disclose things more swiftly and through the process that we have been discussing with them. And this is a matter that has caused concern, and I regret that I've raised it again. But it is raised again because it is being, in our submission, being dealt with differently to the way it's been dealt with in other Article 2 processes, and that's why we raise it.
All right, thank you.
Thank you very much.
Thank you very much. Mr. Thomas. Yes, Mr. Thomas. I've got one eye on the clock because I think we're starting to run late already, and I just mentioned that for the benefit of all those who are going to speak after you. All right?
Mr. Chairman, truth fears no questions. An inquiry is a search for truth through the asking of questions. Critically, which questions asked determines which version of the truth we are left with. We can all agree on that. What we are not yet agreed upon is the importance of the identity of the questioner has on the questions that are ultimately asked and the answers that are ultimately provided. As we embark on the next stage of this vital search for truth, your inquiry remains steadfast that our clients are not allowed to ask questions of witnesses through us, their lawyers. And as we understand it, this will extend to the questioning of our clients themselves when they give evidence. Instead of being taken through their evidence by their own lawyers, they are to be questioned by your counsel, just like the other non-core participant witnesses to the inquiry. We submit that this is highly unusual. There have been several public inquiries, Basamusa, Al-Swady, Litvinenko, Azul Rodney, Anthony Granger. All of these public inquiries allowed the lawyers for the core participants to ask some questions. We invite you to exercise your discretion to permit us to ask questions and not simply allowing this through your counsel. One of the things that you've asked us to address you on is Article 2. Our clients are entitled to effective participation. We can all agree on that. A reasonable inquiry tribunal would permit their views and concerns to be presented and considered. The question is this: do they have effective participation if all the questioning is done through your own counsel? We caution there is a danger that this inquiry may well fail to pass this important hurdle. At the end of the first procedural hearing, in which you accepted that as far as possible, this inquiry should be a vehicle for discharging the Article 2 obligation, and that this inquiry has the capacity and the ability to be flexible, if the families of the deceased are prevented from asking questions through their lawyers, we suggest there would indeed be a breach of their right to fully participate effectively, which is guaranteed by Article 2. In a case like this, Article 2, we submit, entitles a family member to put questions, yes. It does depend on the particular circumstances, but those circumstances are applicable here. In Amin, the High Court held that families should have the right and be able to cross-examine the principal witnesses, and the House of Lords agreed. The particular circumstances included the level of public concern and the issues at stake. The same levels of acute public concern apply here, if not higher. In Letts, the High Court explained that the right of the family to participate in the investigation is an ingredient of the overriding need to maintain public confidence. In this case, there is the highest possible level of concern in this inquiry. The public cannot have confidence in it if the victims are excluded from what is ostensibly the central process of the inquiry. From the very outset, you, sir, have repeatedly stated you will place the victims at the heart of this inquiry. As is well known, this has particular poignancy in the context of the Grenfell Tower disaster. That being so, our clients naturally want to know when. Why are their lawyers not being allowed to ask their questions? Why must they be restricted to inviting counsel to the inquiry to ask their questions in the hope that that invitation will be accepted? Why must they be made to feel like bystanders to an investigation of their own tragedy? It is difficult for them to accept that the only reason why their lawyers cannot ask questions is because it would be impracticable for them to do so. They know, their lawyers know their stories, their feelings, their concerns better than any other. They also know that it's their lawyers who are best able to ensure that all the questions that they need answering get asked. They know that it's their lawyers who will know what vital follow-up questions need to be asked of a particular witness. And they know that counsel to the inquiry can never hope to emanate the intimate knowledge and familiarity with their stories that their lawyers possess. So, how can it be more efficient for counsel to the inquiry to ask all of our clients' questions? Hard-working and effective lawyers they undoubtedly are, rather than their own lawyers. This approach cannot be more effective if the objective is to establish the truth. Even in an inquisitorial context, it is obvious that the search for truth is strengthened by the deployment of different approaches, different hypotheses, and different temperaments. Different witnesses respond differently to different techniques. It is not because our clients are of the view that the witnesses are intent on lying that they wish to ask questions through their own lawyers. In the words of the late John F. Kennedy, the great enemy of the truth is very often not the lie, deliberate, contrived, or dishonest, but the myth, persistent, persuasive, and unrealistic. It is not sensible or realistic to presume that a single line of questioning from the same advocate in the same style or same approach can uncover the hidden depths of the truth. The system as it now stands is, I say respectfully, a little haphazard, with individual counsels passing notes to your counsel, sometimes interrupting his flow and thoughts when he is concentrating on a line of questioning. Although he has been very patient and accommodating, we can see how disruptive this has been for him, and it makes us reluctant to want to interrupt him. An atmosphere of, what is it now, is sensed, even when we use the tiny breaks to impart our points. Rather than this non-systematic approach, it would be simpler, quicker, less frustrating and fairer to all for your counsel, including your counsel, to let the core participant counsel ask a few extra questions which are mostly accepted by your counsel. However stringent the statute appears to be, there is room for a sensible exercise of discretion. Many public inquiries operate in this way. Mr. Chairman, I've nearly finished. It is critical to the deployment of Article 2 that the bereaved, the survivors, are central to this investigation in what happened to them, not only to ensure that they feel fully included as vitally important, but in order to serve the truth. There is everything to gain and nothing to fear by allowing the victims' lawyers the opportunity to ask the questions which their clients so desperately need answers to. We urge you to listen to our concerns and immediately adopt the approach taken in other recent public inquiries and direct that we may ask questions when they, particularly of our own clients when they come to give oral evidence, and indicate that Rule 10.3 and 10.4 applications will be received sympathetically from us in relation to other witnesses. Respectfully, nothing less will do. Those are my submissions, sir.
Thank you very much. Morning. Yes, Mr. Mansell, I have read your submissions, including your lengthy list of proposed matters for consideration as urgent recommendations. I hope you won't think I'm being unkind or rude if I suggest you try and keep the submissions pretty succinct, because I'm a little concerned that we are running behind time.
No, I intend to do that. I certainly do not intend to read out. There are 30 recommendations that we've made, and I'll come to it in a moment, but I think it's worth beginning with something that's not in the submissions, and what I'm going to say itself It is not in the submissions. It's to emphasize one point that we want to get across today. And that is, there can be no more slippage of time or delay in relation to what we've categorized as manifestly obvious, immediate recommendations. Putting it in the vernacular, they're blindingly obvious. They do not require any evidence from phase 2 or any more evidence in phase 1. They do not require expert evidence. They do not require and should not require consultation, because all the 30, which anyone will be able to read, which stretch from the rather banal but important fire extinguisher, high-rise pack type of accessory, which we say in this case, had there been a fire extinguisher available to the occupant of the flat in which it all started, we might not be sitting here. Now, if that kind of recommendation is going to be put back for others to consider, consult and agree, I fear we're going to lapse into, and that is our main point, what has been a culture of complacency over recommendations. It doesn't only relate to inquests, it relates to inquiries. And may I respectfully ask you to reflect on one that happened, and it has a bearing on this one. Safety has never been top of the priorities. It always has lip service that it is, but actually at the end of the day, it doesn't get it. There was a fire at the King's Cross underground station in the late 1980s, 1987. An inquiry was set up which sat for 90 days with very detailed recommendations at the end of it by Sir Desmond Fennell. And one of the main ones was about an emergency radio system for the underground and any other underground situation. Did anything happen about that? The answer is no. Why was it that way? Because we all know, that government, local, national, industry, sit on it. It's what Lord Justice Taylor called, in another context of Hillsborough, the culture of complacency, the culture of inertia, the culture of putting it off for another day. There's always a good excuse, but not for these 30 urgent, immediate recommendations. And we are concerned, as you will perhaps detect from what I'm saying. It is the families who are saying, as I put at the end of the last session, the beginning of August, it's the families who are really concerned that other families do not suffer. Interestingly, on the morning of June the 14th this year, on the anniversary of the fire at Grenfell, you perhaps will have noticed, as others have, on that very morning there were 2 more tower block fires. One in Scotland in Glasgow and the other one in Lewisham. One concerned 14 stories, one concerned 12. What is interesting is what arises out of those, which needs consideration now. In the Scottish case, of course, cladding and combustible materials have been banned, the point that has already been raised, which we say a moratorium at the very least should be considered right now, which of course helped in the Scottish case to prevent risk of spread of fire, risk of death. In the Lewisham case, interestingly, sprinklers came into use. No one's suggesting that that's the be-all and end-all, but it certainly was an ameliorating factor in the Lewisham case. But in addition, the alarm system was found not to work, something that you will be aware of in this case in terms of the effectiveness of an alarm system, one of our recommendations. But the most important thing, perhaps, in the Lewisham case is what did people want to do once they realised there was a fire in a block of flats in London, yet again? The occupants were in a state of confusion. The occupants, some wanted to stay because that was the policy, but the majority wanted to leave. Why? Because they had an awareness of what had happened at Grenfell. So they didn't want to stay put. Now, this situation cannot pertain for a day longer, whereby there is confusion over when it should be abandoned, the policy itself, and what evacuation contingency plans have been drawn up. That depends on whether there has been proper visits to the site, to the individual blocks, so that the fire brigade and others know exactly what the layout is, what doors are locked, what hydrants work, what access there is, and so forth. None of that. You've heard witness after witness. That has not happened in the Grenfell case, but it cannot continue. So, putting it shortly, the suggestion we make now is that, and I'm going to put forward a date, that on Friday the 14th of this month, there is a hearing, a further hearing, on the urgent immediate recommendations in order to see if there can be a consensus. But at the end of the day, even if there isn't a consensus, the obvious ones that you may feel should be preferred are identified, and also by that time it would be, we say, advantageous and desirable for the authorities to indicate what they've done, which is another point that has already arisen. It can be done within 2 weeks. Then I think the public and then I think the families will begin to believe that this inquiry is going to be effective. You have an amazing opportunity to ensure that, unlike Sir Desmond Fennell, who expressed dismay and despair that when it came to the London bombings and the use of underground emergency radio networks which had not been put in place, that you do not face that. And the only way to avoid that is for there to be oversight by you during the duration of these inquiries, and this phase and the second phase, and people have to report back as to what is being done or not being done. And then that will develop into the other two categories that were outlined earlier, categories 2 and 3. Thank you.
Thank you very much. Now, yes, Mr. Menon, do you want to...
I have nothing to add to what I submitted in writing.
Well, that's very good.
I hope I can say that in here.
Yes, of course you can. Thank you very much indeed. Well, Mr. Walsh, are you going first for the what I might call the fire group?
Thank you very much. Yes, the fire group, sir, is the London Fire Brigade, who I represent in this affair, and then the FBU.
I got you down for 15 minutes between you. I hope you've got some sort of...
Well, I'm very conscious of the overrun, so I think I can be a lot quicker as a result of what has already been said by others. And I do intend to be very succinct, as you have asked us to be, sir.
Thank you, yes.
Obviously, I've got no intention of repeating the matters in our written submissions. They speak for themselves.
Yes.
We've considered the submissions made by others, other core participants, and we just want to make the following short observations. Firstly, as to the scope and limitation of evidence to be given by senior LFB officers, we agree with the submissions of the Mayor of London, who takes the view that issues of, quote, organisational structure, response and training should be considered exclusively in phase 2 once Mr. McGurk has reported following consideration of all of the evidence in phase 1. The LFB agrees with that approach for the reasons which are outlined in our submissions. And of course it was the approach, your approach and the approach of the inquiry from the outset, and the brigade can see no reason to change that course now, notwithstanding what has been said before. And of course the primary reason that we rely on for that assertion is that we are all, and that includes the LFB, learning from the evidence which the inquiry has heard and has yet to hear. There is considerable further work to be done not least because the LFB continues to work on the complex process of assessing the operational response for the whole period of the fire, and not just for the first 2 hours. That has been done, but there's further work going on. And so accordingly, we say that it is obvious that if the inquiry is to investigate fully the operational response by reference to policy and training and how that fits into the historical perspective, it can only be achieved properly once all of the evidence is available, including that which is yet to be disclosed for the purposes of phase 2. But of course, senior witnesses from the LFB who may give evidence during the course of phase 1 will, if appropriate and necessary, return for phase 2 to give detailed evidence at that stage. Moving on very quickly to Article 2 issues with regard to the requirement to comply with those with Article 2, the Brigade fully supports many of the submissions made by a number of lawyers on behalf of the bereaved survivors and residents, and will make every effort to identify relevant evidence so as, for example, to populate the table annexed to the submissions of G4. And I have done and will continue to speak, for example, to Mr. Friedman about how we might best achieve that. Yep. But the FSG tracking, which the LFB is in the business of doing now, and the detailed work on the operational response reports should feed into that process. And then finally, urgent recommendations. We have noted the many suggestions made by call participants and the many made, for example, in the submissions of Mr. Mansfield. They're obviously too numerous to address here, but the point which we make strongly in our written submissions, and we make it again today because it is important, is that many of the proposed recommendations may have, actually are likely to have, far-reaching implications nationally, which require consultation. They do require consultation beyond those who are core participants in this inquiry. And we have, as Mr. Millett has pointed out, provided a short schedule of suggested consultees. There is also a need to avoid potential unintended consequences, which a broader consultation would be more likely to identify. The FBU, for example, recognises that fact, but suggests that certain recommendations might apply to London only. But of course, the Brigade submits that urgent recommendations made through this inquiry would presumably only be made, as Mr. Mansfield has just said, where there is an obvious and pressing urgent need, and where the recommendations can clearly, obviously, be implemented as a matter of urgency. And if that is so, then surely they must have national applications, as opposed to apply, for example, to London only. But the tension there is that that may actually require broader consultation. The written representations made on behalf of the Home Office, for example, makes the point that considerable work has been undertaken in certain areas, including the creation of the Fire Standards Board, the FSB, to oversee and consult on professional standards of fire and rescue services. That body is conducted in conjunction with the National Fire Chiefs Council, the NFCC, and the Local Government Association, to whom the LFB will provide substantial assistance. And the point the Home Office makes is that responses from that process should be taken into account when making recommendations. The Brigade, unsurprisingly, agrees with that. But we have made clear in our written submissions that the Brigade has been involved in an ongoing review, of course it has, and has already taken certain actions which it thinks urgent and capable of implementation, and examples are given in our written submissions. We note the suggestions of other lawyers for the bereaved survivors and residents, and in particular Mr. Steen, and we agree that it would be helpful for the LFB to provide a summary of actions which have been taken and those which are under consideration. And we can well see how the inquiry might benefit from that. I will
liaise with Mr. Steen further about what may be required in due course. So we agree with that principle, but we do make this point, that the LFB is conducting and will report more fully at the end of phase 1 and before phase 2. So those two streams of work, the undertaking to give a summary of what has been done and what is in train, is a separate piece of work to the much more detailed report, which will be available by the end of phase 1. So those are my very brief submissions.
That's very helpful.
Thank you very much. Thank you very much.
Yes. Mr. Seward, do you want to add something to your submissions?
So much has been said, I'll try and keep it short. Going straight to urgent recommendations, the FBU has set out what it considers the approach should be, and that is effective use of the experts that are already instructed by the GTI team. We would ask that all recommendations suggested by core participants, whether it be the 7 from the FBU or the 30 from G11 or whatever, all of them should be considered by the experts who should report to you their opinion on the question whether these are appropriate for urgent recommendations. And thereafter, core participants should have an opportunity to address you further in light of what the experts say. But all of this should happen quickly. We welcome Mr. Millett's support of the LFB, the Mayor and the MHCLG saying what's happened so far. We think that should have happened already. There really can't be any scope for much delay in them reporting what's already happened. It is important information and it should be available. Right. That shouldn't be a cause for delay, but it will be instructive. Moving on to the questioning of witnesses, obviously the current system doesn't satisfy everybody all the time, but it does work and it does enable the evidence to be given within reasonable constraints. And it's important, and we would ask you to remember that firefighters come to this inquiry and submit themselves to questioning. They do that voluntarily. They are public servants. They do respect the need for an open public inquiry, and that's why they're here. They take their civic duty responsibly. But they have understood all along that the questioning would be in accordance with Rule 10 of the inquiry rules, and that is part of the package. We would also ask you to recognise the trust that has been built up and which should not be put at risk by opening up the questioning in an inappropriate way. Obviously, there is a discretion in the chairman, and we would hope that that is being kept under review. And it may be that an application would be made that would find favour with you. And we would expect that to be by way of re-examination, not by way of examination in chief, and ask that no, if you like, unsatisfactory precedent be set. We're at an early stage of this inquiry. Lots of witnesses have got to give evidence, and all witnesses should be treated the same. Moving on to the extent and scope of the questioning of senior firefighters, we agree with the approach taken by the GTI team so far with firefighter witnesses, and we can't see why that should be altered for senior fire officers, so that their own training is relevant, what training they had or what training they were given. What training they were given or what training they gave, because a lot of them will have satisfied their training requirements by giving training. So what training did they give is relevant. And although that may well touch upon phase 2 issues, I think some questions could be asked about the part they played in the development of policy, if only to identify witnesses for phase 2. As to Article 2, we would support the BSRs if they would prefer, for more effective participation, a return to the Millennium Hotel. We would support that. When it comes to collating the evidence into a schedule, this is the 999 calls, the admin calls, the radio transmissions, and other evidence. It's a huge task. It's a massive process. We've already put a lot of effort into that, and we have shared some of that work with the GTI team, and we intend to go on sharing with the GTI team.
Yes,
we think that it should be the GTI team that compiles any composite schedule which collates all of that evidence. That's not to say that core participants shouldn't have input. Obviously, as Mr. Walsh has submitted, all core participants should have an input into that schedule, but we think it should be the GTI team that prepares that, not any particular core participant.
Yeah.
So a small point, certainly from our team's perspective, we would welcome some composite directions order so that we don't have to keep checking lots of different emails as to what deadline we've missed and what we need to do next. So a composite, like in civil trials, you get a composite set of directions. Of course, they get amended from time to time, but everybody knows where to look for the directions. And finally, a plea. We still haven't got the names of the control staff who the inquiry intend to call in September.
All right, well, we'll see if we can do something about that.
And we'd like that as soon as possible, because we've got a lot of work to do on that.
Yes, of course.
Thank you very much.
Well, thank you very much. Now, Mr. Brown, do you want to add anything to what's been said? Very good. Thank you very much. Next item on my list is MCHLG, but oh, you're over there, Mr. Beer. I couldn't see you. Yes, come on up. Yes.
So on behalf of the department, can I say 3 things this morning? They all relate to the recommendations issue. Firstly, as you will have seen from our short written submissions, the department wholeheartedly supports the inquiry's proposal to consider the need to make interim recommendations. The department recognises that the fire uncovered widespread failures in the building regulation system and the fire safety regime for high-rise residential buildings. You'll know, sir, that the government has undertaken a wide range of measures in the course of the inquiry, including an independent review of building regulations and fire safety, and that it is minded to ban combustible cladding on high-rise buildings. But the department recognises that, notwithstanding this work, the inquiry may recommend that further actions are undertaken. Secondly, the department has noted the very wide range of views offered by other core participants in the inquiry in their written submissions and this morning as to how the inquiry should go about its task of considering whether to make recommendations. These range from making recommendations forthwith on the evidence that has been heard, to the core participants themselves drawing up lists of recommendations that should be made, to the inquiry indicating the recommendations that it is minded to make, and then core participants making submissions on them. So we do not take a position on these issues. Instead, the department believes that the inquiry should determine for itself the best process to adopt to ensure that good recommendations are made timeously by reference to a proper evidential foundation and which can be implemented so as to secure public safety.
Right.
But third, sir, in order to assist the inquiry with the approach taken, the department does have one suggestion to make. We recognise your previous ruling on that phase one will be a fact-finding phase. Therefore, any recommendations stemming from this first phase will not necessarily have considered why things happened or what should have happened. This wider examination forms a part of phase two and will be an important part of providing the evidential platform for the inquiry's recommendations. We would therefore respectfully suggest that any recommendations made at this stage are made on an interim basis, drawing on the evidence heard in phase one, but should be subject to any additional evidence to be given to the inquiry in phase two. In conclusion, the department stands ready to help the inquiry in any way that the inquiry sees fit, and that includes by providing the inquiry with the type of information identified by Mr. Millett this morning as to past changes since June 2017 and intended changes.
Good.
Thank you.
Yes, thank you very much. Thank you. Home Department. Morning. Yes.
So I represent the Secretary of State for the Home Department, along with Jonathan Dixie, led by Catherine McGahey of Queen's Counsel. Ms McGahey is very sorry that she can't be here today. So we've provided written submissions dealing really with interim recommendations. So if I may, I'll just read out the first paragraph or so of those submissions because I hope they're important. The Home Secretary has listened to the harrowing evidence to date relating to the night of the fire. He would fully support the prospect of you, sir, indicating as soon as possible whether there are any issues which you consider present real dangers to the public and which you believe can appropriately be addressed by way of interim recommendation. And of course, the Home Office will give any such recommendations urgent consideration at the highest level. Many issues, and some very complex, have not been the subject of any detailed evidence at all so far in phase one, and they'll be given careful consideration in phase two. And so we recognise that you may not consider it appropriate to make interim recommendations in relation to those kinds of issues at this stage. However, that doesn't mean that no steps will be taken in the interim to address such issues. Counsel to the inquiry has today suggested that those steps be set out in due course. And perhaps the chronology is this. The independent review, the Hackett review, the final report from that was concluded in May of this year. A written ministerial statement was made in July, and there is a commitment to give a further update with a detailed implementation plan in the autumn. MHCLG are leading on that with Home Office input. Work has started on other issues. You've heard from Mr. Walsh the example that we set out in our written submissions of the creation of the Fire Standards Board. That is an example. Obviously, these are ongoing processes. And as I think Mr. Friedman and Mr. Walsh have set out from different starting positions, for change to be effective, there does need to be careful and broad consultation in some instances. And the Home Secretary respectfully suggests that the recommendations and responses from that process be taken into account when you, sir, consider the need for interim recommendations. And of course, sir, we will put those recommendations and responses before you and the other core participants when as and when they are produced. So the Home Secretary took the opportunity in the written submissions to set out and distinguish how the Home Office role in relation to fire safety can differentiate from those of other core participants and other bodies who have responsibility. An example, perhaps, of this is the list of consultees that London Fire Brigade have produced and counsel to the inquiry has also referenced. So we're not going to repeat that here, but we can, we hope, reassure you that we'll work with your team to ensure that any recommendation is disseminated to the most suitable bodies, and to reassure you that where it's appropriate, the Home Office will work collaboratively with those bodies to deliver change.
Good. Yes, thank you very much. Thank you. Now, it's Miss Studd here for the Mayor. Yes, Miss Studd.
Yes, on behalf of the Mayor, two very short points. The Mayor would support the inquiry's approach, which was indicated this morning, to the senior firefighters' evidence. The reason for that, as the inquiry will appreciate, there's a national picture to be taken into account in relation to recommendations, and there is a real concern that the response of the London Fire Brigade couldn't necessarily be replicated throughout the country due to geographical locations and resources. In fact, as you know from the evidence, the London Fire Brigade were on the scene very quickly, and that's not so easy elsewhere, and so there is a concern that the senior fire officer's evidence should be looked at as a whole so that any recommendations can apply nationally. That, of course, does not prevent any interim recommendations being made. That is something that the Mayor has repeatedly requested, if appropriate, in the interests of the public safety and the safety of Londoners. And the second point he wishes to make is this, that without repeating a submission that he made to you earlier, he remains very concerned about the location of this inquiry, particularly in relation to the evidence to be given by the BSRs in October. He acknowledges the BSR's application to move that part of the evidence back to a location such as the hotel where the memorials were held, and he would urge you to give that your most careful consideration. Yes. Obviously, numbers will swell. This room is not suitable for very many of the core participants to attend. It's impossible for all of the BSRs to attend when they want to. And bearing in mind the sensitivity of that evidence, he considers that the most careful consideration should be given to the location for that. Can I just raise one issue that Mr. Millett raised this morning? He sees no difficulty with a position statement dealing with the changes that have been implemented. I anticipate that his role in that will be somewhat limited, but he would ask for a reasonable time period to complete it, just because of the time taken to investigate those types of issues.
What would a reasonable time be?
Well, I haven't got any instructions on that, but I would think probably 28 days. I'm afraid we didn't have any warning of that in advance of this morning. Thank you very much.
Thank you very much. Now, thank you very much. I'm sorry. I've received submissions from many of the other core participants, but my understanding is that none of them wishes at this stage to add anything to what's been said in writing. I hope that's right. If not, please let me know now. Right. Thank you all very much. Now, Mr. Millett, do you want to say anything in response?
No, I don't, Mr. Chairman. I'm going to leave it to you to consider all the submissions you've read and heard and to deliberate on those accordingly. we start the next witness next. And so I was going to suggest that we take a short break, say 20 minutes or so, to rearrange the room, and then start with the next witness.
If we start Mr. Goodall not before 11:15, is that going to allow enough time?
Yes. As far as I'm concerned, it will, I think, yes.
All right. Well, thank you very much, all of you, for your submissions. There's a lot for me to think about, and I shall give you a response as soon as I can. But I think for the moment it's important that we get on with the evidence. So I'm going to suggest we have a break now. Mr. Millett says that if we start Mr. Goodall at 11:15, we should be able to finish him within the morning.
I don't think I made that indication.
Well, would you like to start him any earlier?
No, I think no. There are various reasons why 11:15 would be suitable for our team, Mr. Chairman. If that's suitable for you and for the witness.
All right. Well, nonetheless, I remain optimistic. We'll break now and resume at 11:15. Thank you all very much.